This next objection we're going to be covering is called hearsay. Hearsay is an out-of-court statement used to prove the truth of the matter asserted. The truth of the matter asserted means that the statement is being used to prove that it was true or has some truth to it. So, for example, I'm gonna kill you. That statement being offered in a court of law by somebody else other than the person who said it is an hearsay statement that is being used to prove the truth of the matter and their motivations or such behind the reasoning they did something. This objection can be used to an attorney in their question if their question pertains to something that was out of court, an out-of-court statement, or something said by somebody else out of court. You may stand up and object, "Objection, Your Honor, this question calls for hearsay." Or if a witness says a hearsay statement, which is more likely, and you may object and say, "Objection, Your Honor, this is hearsay." Or, "Objection, Your Honor, hearsay." You may respond to hearsay by first asking Your Honor to ask opposing counsel what exactly was hearsay or what exactly the statement is being objected to as hearsay, and explain how that statement is being offered to use the proof of the matter asserted. You may argue against this by saying, "Your Honor, this statement is not being used to prove the truth of the matter asserted, but rather to show the subsequent actions or the steps taken after the statement was heard." You can also say that the statement is not being offered for the truth of the matter, but rather to show that it was said and heard by somebody. You can also rephrase your question if it pertained to the question, or you may use a hearsay exception. For context, I am the prosecuting attorney asking the detective on the prosecution about their investigation. What did you do after responding to the 911 call?
After responding to the 911 call, I talked to Jury Moya that told me that they found the body.
Objection, Your Honor. Hearsay.
Your Honor, this is not hearsay because it is not for the truth of the matter, but rather to show the detective's subsequent actions after learning this information.
I ask that this evidence be admitted for that limited purpose.
The first hearsay exception we're going to be going over is declaration against interest. This is exception A. Declaration against interest is when the declarant makes a statement that is against their own economic interest, creates criminal or civil liability, makes them the object of hatred, ridicule, or social disgrace in a community. They would not have said this statement if it weren't true, and a reasonable person would not have said this statement if it weren't true. If the statement applies to any of these, then it is acceptable and admissible in a court of law. What happened when Kieran interviewed you for the job of his holistic wellness coach?
In our interview, I originally told him that I had credentials I do not have.
Objection, Your Honor. Hearsay.
Your Honor, this goes to the hearsay exception A, declaration against interest, because this goes against this witness's own economic interest in saying the statement.
This goes against their economic interest.
Your Honor, in Jury Moyad saying that they lied about their credentials as a holistic wellness coach in court today puts them at risk of losing their job at the said company that they work at.
No response, Your Honor.
The next exception is exception B, excited utterance. This is a statement that explains or describes an event perceived by the declarant, and it was made shortly during or after a exciting event or stressful event. Excited utterance is acceptable and admissible in a court of law because it is being used under the stress of an event. An example of excited utterance is a character or witness getting frustrated and yelling, "I'm gonna kill you," because of an event. That could be admissible in a court of law. The next exception we're going to be going over is exception C, state of mind. This is a statement that explains the declarant's then existing state of mind emotion, or physical condition, and this can include a statement of intent, plan, motive, mental state, pain, or bodily harm. So an example of this would be a declarant saying how they feel to another person who's going to testify to that on stand. This would be admissible in a mock trial court of law. You said that Toby Clark wasn't your biggest fan, isn't that correct?
Objection, Your Honor. Hearsay.
Your Honor, this goes to the hearsay exception C, state of mind.
May opposing counsel please explain how this fulfills that exception?
Your Honor, state of mind is defined as a statement of intent, plan, motive, mental state, bodily harm, or pain. This goes to this witness's motive in framing Toby Clark for the murder.
No response, Your Honor.
The next hearsay exception we're going to be going over is D, records made in the regular course of business, including medical records. This is a writing that is from a government agency or business that is acceptable in a mock trial law of court. Now, to qualify, it has to be a writing or record made in a regular course of business, so in a receipt, a toxicology report, and it has to be made near or at the time of the event. And lastly, the sources of preparation and methods of preparation must be trustworthy. The next hearsay exception is exception E, official records made by a public employee. Now, public employee, it's important to note this, is not a police officer or any sort of expert in the case packet. Those do not apply to this specific exception. Official records made by a public employee must be a recording of the act of an event, and it must be made as the scope of the duty of the employee. The next hearsay exception is exception F, prior inconsistent statement. This exception can be used if a witness said something in trial that contradicts either their written witness statement or something that they had said previously in trial. This is admissible in court because of the contradictory. This can also tie in to exception number G, prior consistent statement. Prior consistent statement is when a witness doesn't say that something that contradicts their previous statements before, and can be used as evidence when somebody tries to bring up prior inconsistent statement. The next exception, exception H, is statements made for the purpose of medical diagnosis or treatment. This is a statement that can be describing medical history, pain, previous diagnosis, and symptoms. So an example of this would be if a witness had a previous medical diagnosis, they can use that as an exception to hearsay. The next hearsay exception is exception I, reputation of a person's character in their community. This can be applied if a reference to a person's reputation and pertaining to their character or character traits is being brought up on stand. Additionally, it has to be brought up at or during the time of the person residing in that community, and or if they were habitually associated with somebody. This next hearsay exception we're going to be going over is exception J, dying declaration. This is a statement made by a dying person about the circumstances of his or her death, or the cause of his or her death. This statement has to have been made with the person's personal knowledge and impending sense of immediate death. The next hearsay exception is exception K, co-conspirator statements. These are statements that are made by a declarant while participating in a conspiracy to commit crime or civil wrongdoing. There are 3 prongs to this exception. The first prong is that the statement must be made in furtherance of the objective of the conspiracy. The second prong is that the statement must be made prior or during the time the declarant was a part of that conspiracy. And the third prong is that the evidence offered either must be sufficient to sustain the first 2 prongs or must be court-ordered as proof to be admissible. The last hearsay exception is exception L, adoptive admissive. Adoptive admissive is a statement that is offered against a party, with that party having the knowledge of it being against them and also adopting it as true. So an example of this would be something that the defendant said that goes against them. Something that they said that could, be used to prove that they are guilty of what they're being accused of, but they decided to use it as evidence, knowing that it's true, making it okay for them and for the prosecution to use it as evidence. The next hearsay exception we're going to be going over is exception M, admission by a party opponent. This is a statement made by a party representative. So for example, the defendant is the defense's party representative, and the statement that they make can be used against them by the prosecution because it was said by the defendant. However, the defendant or the defense cannot use that statement as exemption from hearsay because it is their own party statement. It does not have to be made against the defendant or the defense's interest in using it by the prosecution either.
For context, I am the prosecuting attorney asking a prosecution witness about something that the defendant said. Now, what did the defendant say?
Yeah, Toby Clark told me that if this doesn't get fixed, then there's going to be a bloodbath.
Objection, Your Honor, hearsay.
Your Honor, this falls under hearsay exception M, admission by party opponent.
Your Honor, I would like to ask opposing counsel what exactly qualifies a statement as M, admission by a party opponent.
As the defendant is the defense's party representative, they are therefore the prosecution or the people's party opponent. Therefore, anything said by the defendant can be brought into trial by the prosecution.
No response, Your Honor.